today is to help you gain an understanding of the criteria that's necessary to accept a report of suspected child abuse for assessment, to learn the difference between a child abuse assessment and a family assessment, and to be knowledgeable about the type of information that can be shared. I can't remember if Elisa mentioned this, but if you have questions during the presentation, I'm going to ask you to type them into the chat box or go ahead and just jot them down yourself. And I'll be sure to take time at the end to answer each one of those questions. I have found in previous presentations that many times I'm often answering questions that people have somewhere in my presentation. So hopefully it works well to hold the questions until the end. I have about approximately 45 minutes of material to present. So that will leave us with plenty of time at the end to discuss any further questions that you guys might have or address anything else that I didn't cover.
Roxanne, they said they can't hear you very well. Sorry, I just wanted to pause, leave a pause for you just to let you know. If you want to maybe just even try to move closer to maybe where your mic is. It's not covered, right?
No,
anything? Okay.
Not covered.
Okay. Yeah, because you.
No.
Yeah. Okay. Perfect. Thank you. Sorry.
That's okay. All right. Hopefully this is better. Please let Elisa know in the chat box if you're not hearing me, and I'll make sure I adjust as much as I can. I feel like I'm eating my computer right now, but if that's what helps you hear better, that's okay. So please let me know if you're having a problem hearing. To give you a bit of history of Iowa's child abuse reporting and assessment laws, they were first enacted in 1965, and the Iowa Department of Human Services was assigned as the responsibility and the legal authority to conduct an assessment of suspected child abuse when it is alleged that the legal criteria for child abuse has been met. We refer to this criteria as the 3 C's: child, caretaker, and category of abuse. In order for the DHS to assign a report of suspected abuse for assessment, the alleged victim must be a child, the person alleged responsible must be a caretaker, and there must be an allegation of at least one of the 11 categories of child abuse. The Code of Iowa defines a child as being any person under 18 years of age. And the code defines a caretaker, who we also refer to as a person responsible for the care of a child, as any of the following: a parent, guardian, or foster parent, a relative, or any other person with whom the child resides and whom assumes care or supervision of the child, an employee or agent of any public or private facility providing care for a child, or any person providing care for a child, but with whom the child does not reside, without reference to the duration of care. There are a few exceptions to this caretaker requirement that I will explain shortly. The Code of Iowa defines 11 categories of child abuse, and I will briefly touch upon each of those categories in the following slides. Physical abuse is any non-accidental physical injury or injury which is at variance with the history given of it, suffered by a child as a result of the acts or omissions of a person who's responsible for the care of a child. Physical abuse made up 7% of all child abuse in calendar year 2019. Our second category of child abuse is mental injury. Mental injury is any injury to a child's intellectual or psychological capacity as evidenced by an observable and sustainable impairment to the child's behavior as a result of the acts or omissions of a person responsible for the care of the child, if that impairment is diagnosed and confirmed by a licensed physician or qualified mental health professional. Mental injury is one of our most difficult categories of abuse to substantiate because it does require a licensed physician or mental health professional to confirm that a caretaker has directly caused an impairment in the child's ability to function within their normal range of performance and behavior. It is not, however, required for a report of suspected abuse to be made by that physician or mental health professional for the allegation to be accepted for an assessment. Examples of mental injury could include a child who has delays due to parental inattention, or a child with impairment in their ability to function as a result of domestic violence. In calendar year 2019, mental injury was one of 6 categories that made up less than 1% of all child abuse. So again, not a category that we see often. Sexual abuse is the commission of a sexual offense with or to a child as a result of the acts or omissions of the person responsible for the care of the child, or of a person who is 14 years of age or older and resides in a home with the child. There are 13 subcategories of sexual abuse, and sexual abuse is the first category of abuse with an exception to that caretaker requirement that I mentioned earlier. As described in the definition of sexual abuse, in addition to the acts or omissions of the person responsible for the care of the child, sexual abuse may also be considered child abuse by any person 14 years of age or older who resides in a home with the child. When considering sexual abuse, it is important to understand that not all sexual abuse involves the commission of a sex act. Any sexual behavior between a caretaker and a child is child abuse. It is important to avoid any assumptions also that sexual behavior is consensual just because a person is of an age in which they are able to give legal consent. Like physical abuse, this category can be abuse by omission, which again, the caretaker knew or should have reasonably known that the child was likely to be sexually abused and failed to protect that child. An example might include a case in which a mother knew that her husband sexually abused their child, but still left him as a caretaker, and he continued to sexually abuse that child. In circumstances in which a child has been exposed to the danger of sexual abuse through a caretaker's omission, but no abuse has actually occurred yet, we would look at that as an allegation of denial of critical care, failure to provide proper supervision. An example would include a case in which a parent knew, for example, their teenage child had sexually abused another child, yet they leave that child as a caretaker to younger siblings. In calendar year 2019, sexual abuse made up 4% of all child abuse. Denial of critical care is defined as the failure on the part of the person responsible for the care of the child to provide for the adequate food, shelter, clothing, medical or mental health treatment, supervision, or other care necessary for the child's health and welfare when financially able to do so, or when offered financial or other reasonable means to do so. This category is also referred to as neglect and is accepted for assessment when a caretaker fails to provide care that is adequate for the child's health and welfare. Historically, denial of critical care has remained our largest category of abuse, claiming nearly 54% of all child abuse in calendar year 2019. Some common situations that fall under this category include concerns of illegal drug use or prescription abuse that impacts a child's health or welfare. Obviously, include drug use that's occurring while a child is present, even if that child might be in a separate room or another part of the house. An example of this might include parents who are smoking pot in their bedroom while children are out in the living room playing. Even if the drug use itself isn't in the presence of the child, it's important to consider, it's important to consider that when a person using drugs is expected to be caring for a child again. Sometimes we hear from parents that they're not using in the presence of their kids, but then we learn that they may still be under the effects of that drug when they have resumed caretaker responsibilities for the child. Drug use that occurs when children are not present could also pose a risk to health and welfare for children when they return to that environment. If a parent leaves their drugs or paraphernalia in a location that's accessible to their children, for example, or if methamphetamine has been manufactured at the child's home or in a vehicle they are transported in, or possibly if cocaine is used on a surface of the home that's accessed by the children, it could be absorbed through the skin upon contact. Denial of critical care also includes children being left home alone who do not have the ability to care for themselves. Now, Iowa law does not define a specific age for children to be left home alone, but it is important to consider whether the child has a physical or mental disability, if that child's comfortable being home alone, whether they know how to respond in an emergency, if they have access to a phone and know how to use that phone, if they know how to get a hold of a caretaker, and of course, how long they are left alone must be considered as well. Truancy, on the other hand, is not child abuse in and of itself. However, a child may have a special need to be in school because of a diagnosed disability, where they receive specialized services at school to meet their needs during the school day. When those children do not attend school, those needed services, they don't get those needed services, and that could be denial of critical care. When it comes to concerns with children riding in motor vehicles, Iowa law does not consider it an unrestrained child to necessarily be abused with that information alone. But we do not need to wait for a child to be injured in a motor vehicle for it to be considered abuse. If the life or health of a child is endangered, for example, a person drives recklessly while a child is in their vehicle, or if a person is driving under the influence of a substance, these would be considered denial of critical care. There are 8 subcategories of denial of critical care, and those include failure to provide adequate food and nutrition, failure to provide adequate shelter, failure to provide adequate clothing, failure to provide adequate health care, failure to provide the mental health care necessary to adequately treat an observable and sustainable impairment in the child's ability to function, gross failure to meet the emotional needs of the child's necessary for normal development, failure to provide for the adequate supervision of the child that a reasonable and prudent person would provide under similar facts and circumstances when the failure results in the direct harm or creates a risk of harm to the child. And finally, failure to respond to the infant's life-threatening conditions. This is also known as withholding medically indicated treatment, including appropriate nutrition, hydration, and medication. Prostitution of a child would be assessed when there is reasonable belief that a caretaker allows, permits, or encourages a child to engage in a sex act in exchange for money or other goods or services. This category of abuse is utilized less frequently since the implementation of our child sex trafficking category that I'll talk about here shortly. In calendar year 2019, prostitution of a child was one of those 6 categories that made up less than 1% of all child abuse. Presence of illegal drugs, also known as PID or PID, occurs when an illegal drug is present in a child's body as a direct and foreseeable consequence of the acts or omissions of the person responsible for the care of the child. Most commonly, we see the PID category as a result of prenatal exposure. A pregnant mother, for example, uses an illicit drug or exposes herself to an environment where illegal drugs are being used, and that results in their child being born with the illegal drug in their body. Children are also exposed to postnatally in circumstances such as a mother who uses illegal drugs and passes it to the child through her breast milk, or a caretaker who allows a child to be in an environment where the child is exposed to illegal drugs or has access to ingest illegal drugs. Presence of illegal drugs made up 7% of all child abuse in calendar year 2019. Dangerous substance is a category of abuse that was modified in 2017, was previously known as manufacturing or possession of dangerous substance. Today, dangerous substance occurs when the person responsible for the care of a child and in the presence of a child unlawfully uses, possesses, manufactures, cultivates, or distributes a dangerous substance, or knowingly allows another person to do so, or possesses a product with the intent to use the product as a precursor or an intermediary to a dangerous substance in the presence of a child. Now, dangerous substance also occurs when a person responsible for the care of a child unlawfully uses, possesses, manufactures, cultivates, or distributes amphetamine, methamphetamine, or chemical combination of chemicals that are used or intended to be used for the manufacture of an illegal controlled substance in a child's home, on the premises, or in a motor vehicle located on the premises. And this applies even if a child is not present, because of course, those substances pose an extra risk that remain a risk when a child returns to that environment. Dangerous substance is the second category of abuse with an exception to that caretaker requirement. While dangerous substance category can only be considered child abuse when the person responsible is a caretaker, the DHS is required to open a child in need of assistance assessment if the person responsible for the dangerous substance is another adult member of the household in which the child resides. So even if they're not a caretaker, but they reside in the child's home. Dangerous substance is our second largest category of abuse and totaled 27% of all child abuse in calendar year 2019. I've included the full legal definition of dangerous substance here, but as you can see more clearly in the blue and bolded font, dangerous substance includes amphetamine, methamphetamine, chemicals used to make an illegal or controlled substance, cocaine, heroin, and opium or opiates. The dangerous substance category, as I said, requires unlawful use, possession, manufacture, cultivation, or distribution of a dangerous substance or knowingly allowing someone else to do so in the presence of a child. For this purpose, in the presence of a child means in the physical presence of a child or occurring under other circumstances in which a reasonably prudent person would know that use, possession, manufacture, cultivation, or distribution may be seen, smelled, ingested, or heard by a child. The second part of this definition just means that a child doesn't have to be standing in the mix of all that use, possession, manufacturing, etc. If the child's in another room, on another level of the home, or even outside of the home at the time of the use, possession, manufacturing, cultivation, or distribution, it is considered to be in the presence of a child. Bestiality in the presence of a minor is assessed when there is reasonable belief that a sex act between a person and an animal occurred in front of a child, and that the caretaker either committed the acts or allowed another person who resides in the home to commit the acts in front of the child. In calendar year 2019, bestiality in the presence of a minor was one of those 6 categories of abuse that made up less than 1% of all child abuse. Allows access to a registered sex offender is defined as knowingly allowing a person custody or control of or unsupervised access to a child or minor after knowing that person is required to register on the sex offender registry. There are exceptions to this category that include when a registered sex offender is the child's parent or guardian, or the registered sex offender is married to and living with the child's parent or guardian, or the sex offender is a minor child living with their own parent, guardian, or foster parent. In calendar year 2019, allows access to a registered sex offender was, again, one of those 6 categories of abuse that made up less than 1% of all child abuse. Allows access to obscene material occurs when the person responsible for the care of the child has knowingly allowed the child access to obscene material or has knowingly disseminated or exhibited such material to the child. In calendar year 2019, allows access to obscene material was again one of those 6 categories that made up less than 1% of all child abuse. And the final category of child abuse, child sex trafficking, is defined as the recruitment, harboring, transportation, provision, obtaining, patronizing, or soliciting of a child for the purpose of commercial sexual activity. So essentially, any role you have in child sex trafficking. Commercial sexual activity means any sex act or sexual explicit performance for which anything of value is given, promised to, or received by any person, and includes but is not limited to prostitution, participation in the production of pornography, and performance in a strip club. Child sex trafficking is the 3rd category of abuse with an exception to that caretaker requirement, and states that any person responsible for trafficking for a child for commercial sexual exploitation or sexual activity is considered child abuse. In calendar year 2019, child sex trafficking was again one of those 6 categories of abuse that made up less than 1% of all child abuse. Now that I've covered the 11 categories of abuse, I'll go ahead and take you through the process in which reports of child abuse are made and assessed. Reports of suspected child abuse are called into the Department of Human Services Abuse Hotline at 1-800-362-2178 during business hours, Monday through Friday, which is 8 a.m. to 4:30 p.m. The calls are processed by our centralized service intake unit. The majority of this unit is comprised of social workers who are dedicated to taking calls, and they do not carry caseloads. On average, this intake unit handles 75% of all the calls for the state. The other 25% is handled by local service area child protection workers who are on call after business hours from 4:30 p.m. to 8 a.m. Monday through Friday, and also on weekends and holidays. All reports of suspected abuse are written up as an intake. A decision then to reject or accept an intake is made based upon the 3 C's criteria that I explained earlier. If the alleged victim is not a child, if the person alleged responsible is not a caretaker, with the exceptions that I mentioned regarding sexual abuse, dangerous substance, and child sex trafficking, or if the allegation does not meet a category of abuse as defined by law, then the intake is rejected. Rejected intake information is always considered for the appropriateness of a China assessment and is also referred to any DHS program that might have involvement with any subjects that are listed on the intake. A social work case manager, for example, would receive the intake information regarding any child or family in which they have an open service case for. Rejected intake information is also referred to law enforcement when there is an alleged criminal act harming a child. An example of this would include an allegation of sexual abuse to a person who is 18 years of age or older, or where the person alleged responsible is not a caretaker or a household member who is 14 years of age or older. These rejected intakes are maintained for 3 years, and the DHS is able to use this information to assist in making a determination on any future calls of alleged abuse. On the other hand, if the alleged victim is a child, if the person alleged responsible is a caretaker or meets one of those caretaker exceptions, and if the allegation meets a category of abuse as defined by law, then the intake is accepted. An accepted intake is assigned for either a family assessment or a child abuse assessment. A screening tool based on Iowa law and administrative rule is utilized to determine if the accepted intake must be assigned as a family assessment or a child abuse assessment. The 12 items that I have listed here on this slide are the criteria that are set forth in law and rule. If any of these criteria is met, the accepted allegation is not eligible for a family assessment, which is our alternative path, and must be assigned as a child abuse assessment. As you can see from this list, an accepted intake is not eligible for a family assessment if the allegation of alleges abuse that involves a category other than denial of critical care, if imminent danger, death, or injury to a child is alleged, if the allegation requires a 1-hour response, if there's a separate incident already open that requires a child abuse assessment, if the child's been taken into protective custody by a doctor or possibly law enforcement as a result of the allegation, if there is an open DHS service case already, if the alleged person responsible is not the parent, legal guardian, or member of the household, if there's been a previous termination of parental rights, if there's been confirmed or founded abuse within the past 6 months, if it is alleged that illegal drugs are being manufactured or sold from the home, if the allegation is failure to thrive, failure to respond to an infant's life-threatening condition, or if the allegation involves an incident for which the caretaker has been charged with felony-level neglect, abandonment, or child endangerment. Again, what I've just listed are the criteria that would require the DHS to assign a child abuse assessment rather than a family assessment. To give you an example of how these assessment types break out, in 2019, the DHS conducted 33,004 child protective assessments. 6,543 of those, or 20% of them, were assigned as a family assessment, while 26,461, or 80% of them, were assigned as a child abuse assessment. Once the assessment type is determined, there are a few notifications that must take place. While child abuse information is confidential, there are times when information is allowed or even required to be shared. During the intake process, the DHS is required to notify the reporter about whether the report of suspected abuse they have made is rejected or accepted for assessment. And this notification is provided to the reporter before they end their call, and also in writing, provided that the reporter leaves their contact information. The appropriate DHS service area is then notified of the accepted intake, so they may assign a child protection worker to the assessment. Parents are also notified when an intake is accepted for an assessment as it relates to their child. This notification is provided in writing and also in person as the child protection worker initiates their assessment. And that notification happens whether that parent is the person allegedly responsible or not. Finally, the county attorney and juvenile court are notified of every intake in their respective counties, whether that intake is accepted or rejected. To review the intake process, this is kind of a fun little chart that kind of lays everything out there for you, but all calls are filtered through the DHS abuse hotline, as you see there on that very top center box. Reports of suspected abuse are written up as an intake as you continue to follow that box down. The intake is either rejected or accepted for assessment. If the intake is rejected, appropriate referrals are made and the information is maintained for 3 years. If the intake is accepted, it is assigned for either a family assessment or child abuse assessment. So what is the difference between a child abuse assessment and a family assessment? Generally speaking, a child abuse assessment prioritizes the assessment of a child's safety and evaluates risks that are present, which make a family more vulnerable to future abuse. In a child abuse assessment, safety is typically addressed within 24 hours from the time that the report of abuse was made. However, if a child is believed to be in imminent danger, then safety would be expected to be addressed within 1 hour. A determination of whether or not child abuse is substantiated and placed on the child abuse registry is also part of a child abuse assessment. A written child abuse assessment report is required within 20 business days, and that report must include recommendation for intervention. Any report that is founded or confirmed with high risk is referred for formal DHS services. In a family assessment, you see that the assessment of child safety is also prioritized, and risk factors are evaluated to determine the family's vulnerability to future abuse. In a family assessment, safety is addressed within 72 hours and from the time the report of suspected abuse was made. The biggest difference in a family assessment is that there is no determination of whether or not the alleged abuse is substantiated. This is because a family assessment involves less serious allegations of abuse and provide an alternate response for a family to correct the issue that brought them to the DHS's attention without concern of having the abuse placed on the Central Abuse Registry. A written report for a family assessment is due within 10 business days. The information gathered from this assessment helps guide whether there are any recommendations for intervention appropriate for the family. These interventions would include voluntary services that are available within the community, and they do not include formal DHS involvement or court oversight. This is another visual depicting the commonalities and differences in a child abuse assessment versus a family assessment. I'm a visual learner, so I like to throw lots of these visuals out here for you to kind of grasp it and retain the information as much as possible. As you note, the first commonality here is safety first and foremost. Safety constructs are used to assess the safety of a child with their caregivers and in their home environment. Safety constructs include threats of maltreatment, child vulnerability, and caretakers' protective capacities. So threats of maltreatment are aggravating factors that are present, which combine to produce a potentially dangerous situation. A home that has a significant health or safety hazard present, for example, would be a threat of maltreatment. Child's vulnerability is the degree to which a child cannot avoid, negate, or minimize the impact of present or impending danger. A child's age, their developmental level, and any physical impairment, for example, impacts a child's level of vulnerability. The caretaker protective capacities are the family's strengths or resources that reduce, control, or prevent threats of maltreatment from arising, as well as risk factors that have a negative impact on child safety. Extended family supports, for example, could assist to reduce threats of maltreatment, while parent substance abuse could increase those threats of maltreatment. At the conclusion of a safety assessment, after the safety constructs have been evaluated, there are three possible outcomes. The child is either safe and no further action to address safety needs to be taken, or the child is conditionally safe and a safety plan is required to address safety, or the child is unsafe and the circumstances require the child to be removed. It is important to note that in a family assessment, the child must be safe by the close of the assessment. If not, that assessment is required to be reassigned to a child abuse assessment. In a child abuse assessment, the child protection worker must also determine whether or not the alleged abuse is substantiated. To accomplish this, evidence is collected and evaluated through observations and interviews with the child victim, their parents, the alleged person responsible, and any other person who may have information regarding the alleged abuse. These additional persons often include school, law enforcement, or medical personnel. To substantiate abuse, there must be a preponderance of evidence, meaning the evidence must be of greater weight or more convincing than the evidence which is offered in opposition to it. As you can compare in this illustration, the burden of proof in a child abuse assessment is preponderance and requires evidence to be at least 51% to substantiate. Most criminal evidence, on the other hand, is required to be clear and convincing or beyond a reasonable doubt to prove guilt. This explains why there are times in which the DHS is able to substantiate abuse, but there may not be enough evidence for law enforcement to criminally prosecute. When the DHS makes a determination as to whether or not abuse occurred, there are three possible outcomes: not confirmed, confirmed, and founded. Not confirmed means there was not a preponderance of evidence to suggest abuse occurred, and therefore the incident is not placed on the Central Abuse Registry. Confirmed means that there was a preponderance of evidence to suggest abuse occurred, but the incident was minor and isolated and unlikely to recur. The law allows only three types of abuse to be confirmed. Those include physical abuse, denial of critical care, failure to provide proper supervision, and denial of critical care, failure to provide adequate clothing. When an incident is confirmed, the abuse is substantiated, but the incident is not placed on the child abuse registry. Founded outcome means there was a preponderance of evidence to suggest abuse occurred, and therefore the incident is placed on the Central Abuse Registry. Founded abuse remains on the registry for 10 years, although there are circumstances that do allow a person to have their name removed from the registry after 5 years. Following an assessment, the child protection worker makes a recommendation for services by analyzing safety and risk factors that affecting the child and family, identifying what available services are appropriate for the child and family, and determining whether formal DHS child welfare services and court involvement are needed for the child and family. Recommended interventions may include information provided to the family or referrals to services that would be available in the community, non-agency voluntary services, formal DHS case management services, which may include additional contracted family-centered services, and court involvement, including adjudication as a child in need of assistance, and possibly also criminal court action. At the conclusion of an assessment, there are additional notifications that must be placed. As stated earlier, although child abuse information is confidential, there are times when information is allowed or even required to be shared. Following the assessment process, the DHS is required to notify all subjects and the mandatory reporter about the outcome of the assessment, informing them whether or not the report was substantiated. So if it was not confirmed, or founded. Subjects of a report include a child named in a report as a victim of abuse, or that child's attorney or guardian ad litem, a parent or attorney for the parent of a child named in the report as a victim of abuse, a legal guardian or legal custodian, or that person's attorney of a child named in a report as a victim of abuse, or a person or the attorney for any person named in a report as having abused a child. All of these subjects receive a copy of the written assessment report, and mandatory reporters have the ability to request a copy of a founded report. As with intakes, the county attorney and juvenile court are also notified of the assessments in their respective counties. Here's that flow chart once again, which provides an overview of the entire process from intake through assessment and services. To review this, on the right side of the chart shows the family assessment process. Again, it requires observation of the child within 72 hours, a safety and risk assessment to be completed, a written report regarding the alleged abuse within 10 business days. If the child is safe at the conclusion of the family assessment, recommendations for appropriate services are made. If the child is not safe at the conclusion of a family assessment, the incident is reassigned as a child abuse assessment. On the left hand of that side, you'll see the child abuse assessment process. Just to review, observation of the child is made within 24 hours or 1 hour if there's an imminent danger. A safety and risk assessment are completed, and a written report regarding the alleged abuse is completed within 20 business days. There is a disposition or finding as to whether or not abuse occurred, and recommendations for appropriate services are made. I know that was a lot of information to review in a fairly short amount of time. So I hope you all have a better understanding about that intake and the intake and assessment process of child abuse. But I'm sure there are plenty of questions or maybe things that I didn't cover at this time. So we have plenty of time, I'm sure, to discuss those questions or outstanding things that you may want to discuss. So I'll ask Elisa to check that chat box and see if anybody has typed anything in, or if anybody has any additional questions that they can answer when you are unmuted.
Thank you, Roxanne. Can everybody hear me okay? You can type yes. Thank you. So I know I got a lot of questions, Roxanne, because your mic was in and out, if you would allow access to your PowerPoint slides.
Yes, absolutely. Yes, I will send those out to you after we're done here today. I will send that out to Elisa and she can forward that on to everybody.
Thank you. Yep. I will do that. So my process, participants, is I have everybody's emails that registered through Eventbrite. So you'll get a post survey and probably the PowerPoint together in one email. So look for that. Sometimes those Eventbrite ones go to your junk. So definitely check that as well. So you had a couple questions. Let me scroll up and start with some of the ones that were typed earlier. Okay, just a second. Got a lot of yeses I gotta go through. Let's see, where did I see that? Somebody needs to mute their mic right now, but I think I can go ahead and do it. We're gonna do just questions via the chat, not live chatting, just for background noise. But I think I can hear somebody's background, but I can mute everybody too, so. Okay. So I had a question, Roxanne. Oh, I gotta unmute you so you can, okay, yep, there. When I mute everybody, it muted you too. That asked about the different, so the rates, was the denial of critical care the #1 in 2019 for how many rates of cases came in?
What was the question?
What
was the rate?
Of the 11 categories, was the
Yes.
denial of critical care the #1?
Yes, yes. Denial of critical care is the #1 category of abuse. And
Okay.
all of that information as well regarding our data is available on our DHS website. So that's something you can always look for too. It's under child abuse statistics. And we have a breakout with an Excel spreadsheet that you can even barrel down just to a county specific. It gives information about types of abuse, ages of victims, the number of victims that were part of an assessment, unique victims and duplicative victims. Lots of good information on there. And then there also is a summary page that kind of gives like a one-pager review of all of our child abuse statistics. So that's a really good resource if you're interested in looking more into our child abuse data.
Laura W. asked a question. I'm not quite sure. I might have her, if she's on, kind of clarify right now, but it said the 4th of the 11 criteria, the 4th one on the list, would that go back to a 3-year reporting area, is what she's asking. So I don't know if you want to go back to that 11 category.
The 4th category of abuse that I covered?
Yeah, she said, does that go back? How many years would that go back that you can report that?
All abuse, there is no time frame on any of our categories of abuse to be reported, so long as that person is a child.
Yep.
So if the victim is a child, if the you know, the abuse happened when the victim, say the victim was sexually abused when they were 4 years old and they're now 14 years old, we would assess that. That same holds true. While sexual abuse is probably one of our most common categories that we see a delay in reporting in, usually because child's scared or maybe didn't even realize what was happening to them until years down the road. That's a category that we commonly see might be a delayed reporting. Most of our other categories, we tend to learn about those within a shorter amount of time. However, if we do hear about abuse, if someone reports abuse to us that happened years ago, we will still look into that, assuming it meets all of that criteria that I covered.
Thank you. I hope that helps, Laura. If you have a follow-up, I'll get to it. I haven't scrolled down to all of them. I'm taking them one at a time. Okay, the next one is from Jenny. She asked, does someone know the exact actions one needs to get removed from the registry? I don't know, she didn't specify the sex registry, but can you be removed? How does that process work to get removed from the child abuse registry?
Yes, yeah, I'm assuming she's talking about the child abuse.
Yeah, not the sex abuse, that's a separate one, sex
yeah,
registry.
Yeah, and just to clarify, because people do get confused about that. People think that we oversee the sexual offender registry, and that's not the case. That sexual offender registry, whether it be the Iowa Sex Offender Registry or the National Sex Offender Registry, is a law enforcement function. So that is all taken care of from Department of Public Safety, totally separate entity than the Department of Human Services. The Department of Human Services is charged with maintaining the Central Abuse Registry, which includes both the Child Abuse Registry and the Dependent Adult Abuse Registry. And so for child abuse, when a person is determined to have abused a child and it doesn't meet one of those categories that we can say it's minor, isolated, and unlikely to recur, then the law does require those to be placed on the Child Abuse Registry. Now, the law says that information has to stay there for 10 years or for 10 years from the most subsequent founded abuse. So if there's abuse that occurs and then in 2 more years, we have a second substantiated abuse, now that first incident is required to stay on for a total of 12 years. And if the abuse continues to occur within that 10 year time frame, then all of the abuse that is part of that string of abuse, let's say, would be maintained on the Central Abuse Registry until there were 10 solid years without founded abuse. Now, that information is required to be on the Central Abuse Registry for that time period, and there are no exceptions to that. However, there have been in the previous years, there have been some changes to law that allow for a person's name to be removed from the registry. So as I talked about, there's a couple of things that I'll refer to on that. So one, if a person is placed on the registry, and like I said, if there's continued abuse for that victim, so if the victim continues to be abused or the perpetrator continues to perpetrate abuse, then it requires that abuse to remain on the Central Abuse Registry. But let's say, for example, I had founded abuse against me 10 years ago. So it's been 10 years now, and I haven't committed any further abuse to a child, but that child has been abused by somebody else within that 10-year time frame. Then the Child Abuse Registry would be required to maintain that information. However, my name could be removed from the Central Abuse Registry. And the important part of that is so that if I go to apply for a job or somebody's doing background checks on me for some reason, then it would not provide a hit or say that I have abuse against me. So that's an important piece of being able to have your name removed after 10 years if you haven't had any further abuse, even if the child continues to be victimized. The second option is there are certain categories of abuse. Those include denial of critical care, physical abuse, and presence of illegal drugs or PIDs. And Those three categories, assuming they meet some other criteria, like they don't include the death of a child or injury to a child, or serious injury to a child, I should say. And there's no further abuse that occurs within a 5-year period, then those categories of abuse are allowed to be removed from the Central Abuse Registry within 5 years. So that's more recent criteria that's been put in place. So we are actually just starting to see some of those names fall off the registry because they did meet that 5-year criteria. Does that answer your question about the Central Abuse Registry? Hopefully.
Hopefully, yeah. I haven't seen if she
not, let us know.
Commented. Yes, if you have more follow-ups, I'm running my list down the line. Thank you, Roxanne. Your next question from Nancy says, what happens when it goes to the county attorney? Is that the only way to determine if legal action is needed?
So I'm going to answer this a couple different ways because there's more than one way for juvenile court to be involved. And juvenile court is the court that oversees all child in need of assistance petitions, which is what we do at the Department of Human Services. Those are the cases we work with. And they also oversee all delinquency cases. And those are the cases that juvenile court services deals with regarding children who have committed crimes and are under the age of 18. So when we have an assessment, I'll start from the intake perspective, when we have an intake, we complete that intake and we determine whether it's accepted or rejected. The county attorney gets that information, whether it's accepted or rejected. So even if we never reach out to them about taking action on that family or being more formally involved, they have the authority as a law enforcement entity to approach the courts about filing a child in need of assistance petition. That doesn't generally happen, but it is an option. They have that authority. Generally, the county attorney would wait for us to complete an assessment. And once we complete that assessment, as I mentioned earlier, part of our requirement at the Department of Human Services is to make a recommendation as to whether or not juvenile court needs to be involved. Now, generally, if we're working with a family who is very cooperative, they are accepting the concerns that brought us to their attention, and they're willing to work with us and voluntarily work with our service case managers and any kind of services we recommend. Then many times we don't recommend court get involved, and we don't need to because the family is being cooperative, the child's still at home, we have safety in the home. But if a child is removed, or even if a child remains at home, but we believe there needs to be a higher level of oversight and court involvement, then we can make a recommendation to the county attorney to file a child in need of assistance petition. The county attorney would draw up that paperwork then, or sometimes the department assists in that. And it's presented to a juvenile court for a judge to make a determination ultimately about whether or not that child will be adjudicated. If a child is removed, that automatically kind of starts the adjudication process. That doesn't mean a child is automatically going to be adjudicated if they're initially removed. It just means that there was concern enough to initiate that process and allow a judge to make the final determination about whether adjudication is necessary. So there are various avenues in which a child can come to the court's attention and child in need of assistance petition can be filed. But that's us having an intake, doing an assessment, and providing recommendations to the county attorney is probably the most common avenue for that to happen.
Thank you for that answer. I think this might be the same person, Nancy. She also asked, who has access to the abuse registry?
So people who have access to the abuse registry include the subjects themselves. So as I mentioned earlier, that would be the child victim, that would be the person who's alleged responsible, and the parents of the child victim. And of course, any of their attorneys, or if there's a legal guardian as well, in addition to parents. Those people have access to that information because they are subjects of that report. However, the law does allow some release of additional information, or release of that information to some additional people. And that is clarified very specifically in Iowa law. So there's a code section 235A.15, which specifically indicates who has access to child abuse information. And it lays out what level of access somebody might have access to. So for example, those that have access to child abuse information generally would have access to founded child abuse information only. So if somebody's inquiring about whether or not somebody has abuse against them, if they are one that we can share information with, then we would confirm yes or no that they are or are not on the registry for founded abuse. There are a smaller number of people that code section allows to have access to our confirmed or not confirmed cases, but that is a lot smaller number. And again, is identified in that code citation I mentioned. And ultimately, any subject of a report can allow anybody to have access to that information if they sign a release of information. So there's some people who have access to that information without the subjects giving approval, but the majority of people do not and would require a release of confidential information for them to access that.
Okay, thank you, Roxanne. Next one's from Alex. Alex asks, for qualification of sexual abuse, at what point do you consider sexual abuse if a minor is the abuser? Are there age restrictions? Do you want me to repeat that?
So if you've been following the changes that we've had to that abuse category over the years, there have been a number of modifications to sexual abuse. So originally, sexual abuse was only determined to be child abuse if it was perpetrated by a caretaker. So in that circumstance, there's not an age at which we say a caretaker is not responsible. If they're a caretaker and sexual abuse is committed to a child, it is child abuse. I would say those examples would include children that are left as babysitters or providers of care to children. So I think, pretty commonly around the age of 12, kids start to babysit other kids. And so if there was sexual abuse occurring during in a circumstance like that a person was a babysitter for a child and they sexually abuse them, it doesn't matter what their age is. If they are considered a caretaker of that child, then they would be responsible for child abuse. There have been some changes in the law over the years. There was a change that allowed or that required us to accept a case of sexual abuse for any abuse that occurred to a child by any other household member, and that created a lot of difficulties, and we had to really process through what that meant, because of course, as young children, children are curious about their body parts, about other people's body parts. And so you see very commonly in child development, interest and exploration of those things they're interested in, especially in those toddler years, in those younger years. So during that point, we were seeing allegations being called in regarding young children having inappropriate touches to each other. You know, 2, 3, 4, 5-year-olds. I mean, kids that you obviously are not leaving responsible as a babysitter or caretaker to the other child, but they were engaging in some level of sexual activity. And so in those cases, when that law was in place, you know, we really have to evaluate, you know, the abuse, if there is abuse occurring, or is it this really just normal child development, healthy sexual exploration. The other side of that required us to also look at, is there potentially, is this happening because the child was sexually abused themselves and they are reacting to what has occurred to them? So that requires us to back a little bit more and look a little bit closer at that circumstance and understand not just what the children are doing with each other, what type of sexual activities are going on, whether it's fondling or whatnot, but why it's occurring. So exploring, you know, what they know and why they know the information, and determining if it's beyond what would be within the normal, healthy development of a child. That law has since been changed to now not include all household members, but to include household members who are 14 years of age or older. So now if we get allegations of sexual abuse, that include, again, a caretaker is always something we are going to accept and discuss. If there is an allegation of caretaker committing sexual abuse. But now, if there is an allegation of sexual abuse to a child who's in a household with somebody who's committing the sexual abuse that is at least 14 years of age or older, even if they weren't considered a caretaker per se, then we would be looking at that as well. And again, the same kinds of things come into play. We're looking at, you know, all those things. We're looking at, are children developmentally on target? Are there other circumstances? So yeah, we would have to evaluate all of those things. So age is only considered when it comes to a non-caretaker circumstance.
Thanks, Roxanne. This is a two-part question about, I think, probably mothers that are pregnant. It says, are moms tested? So if they maybe are using an illegal substance, is what I'm assuming. They didn't, it says drug. So, and then at what point are the babies tested in utero or maybe post-birth? And then are they automatically removed from the household if they test positive, the infant? Does that make sense, that set of questions? Roxanne, are you with us? She might have frozen. Roxanne, can you hear us? Can you hear me? I'll give her a couple minutes, participants. She might have had some bad internet access. Okay,
yes.
You're moving. There we go.
Yeah,
Okay.
so here are two questions, one about testing and one about the removal.
Yes, and then if mother.
Yes, can you hear me?
Yeah, we can.
Can you hear me?
Yes, yep.
Yeah, I can hear you.
Okay.
Yep, can you hear me?
Can everybody hear her again better? You're more clear. Maybe that's your internet.
I'm here.
Okay, go ahead. And do you want me to reread that question, or can you?
Okay. Yes.
Okay. Reread it.
Okay. All right, can you hear me okay still?
Yes, yep. So are babies tested?
No, I think I got it. So the question was about when babies are. No, so the question was about when babies are tested, and removal is assessed. Okay, so I just want to make sure you hear me okay. So as it relates to testing, um,
Did we lose her again?
sorry, now you're frozen on me. Hopefully you can hear me now.
Yes, we can.
Can everybody hear me? You hear me?
I'm getting some yeses.
Am I frozen again?
We can't see you, but we can hear you, so this is good.
Yeah.
No, I can hear you now. You cut out on me, but I can hear you now. Okay. So to answer the question, let me know if, okay, great. Sorry about that. I don't know what the connectivity issue is.
It happens.
Okay. So when it comes to testing a child, many times that's happening at birth if there's concern about drug use. And so hospitals all have different protocols as to when they test a child. And that's a lot of times how we get involved. And so if the hospital doesn't test a child upon birth, or the child's older and there's concerns about the child having drugs in their system or having access drugs, then we can ask for a drug test to be done. And in those cases, removal does not always happen. And in fact, if we can prevent removal, that is our priority. We do not want to remove kids from their families. Children do best with their families. And the last thing we want to do is take them from that environment if we don't have to. Now, of course, there are circumstances if we, like I mentioned earlier, with our safety assessment, when we're assessing for safety, we're looking at all types of possible present and impending danger. If we identify that there is present or impending danger, which of course would be a parent's active substance use and potentially a child being positive for a substance or having a substance in their body as a result of a parent, that doesn't necessarily mean that child's going to be removed. Because of course we want to help get the family to a point where they're not relying on that substance anymore. And we think that's best to do by keeping the child at home if we can. So the priority would be, if we do have signs of present impending danger, would be to try to do a safety plan to bring resources in around that family and that child to make sure that child is safe while they're still in that home. So that could look like maybe a non-using parent or a non-using relative being present in the home and providing the majority of the supervision for a child. That could look like maybe a child going to stay with a relative while the parent maybe goes in for inpatient treatment or something. You know, there's lots of different things we can consider, but ultimately, if a child remains in the home, we are keeping them there with the understanding that either one, the child's already been determined safe, or that there are factors that we put in place, you know, through a safety plan to assure that child's safety. If we can't assure that, then that is the time that a child would be removed. And the Department of Human Services does not have that authority to remove a child ourselves. We have to consult with a judge who makes the ultimate determination about whether or not we have the legal authority for that child to be removed from the home. They make that decision and we effectuate the removal. But it's, you know, in collaboration with information about what is happening with that case. So hopefully that answers your question.
Thank you. So the next one says, can you give a few more examples of what qualifies as mental emotional injury?
Mental or emotional injury? Yeah, like I said, that one's a hard one. So essentially what it comes down to is any an action by the parent or caretaker that is causing a child to function outside of their normal range of development. So like I talked about, I talked about the example of physical abuse. I'm sorry, domestic violence I talked about. So, you know, if a child is witnessing domestic violence in their home, And maybe as a result of that, they're terrified to be at home. They're anxious to be at home. They're not eating. They're losing weight. They're not sleeping. They're not able to focus on anything, in their school activities or any other thing they might be involved in, because they're very anxious about what's happening in their home environment, and it just totally takes over their functioning ability, and they're not able to function in the developmental range that a child should be able to function. That can happen with more than just domestic violence. That could happen with any type of I guess, like terrorizing a child, or any action from a parent that causes that child to result in having the inability to function normally. So that's really a wide range of things. Sorry, I'm not coming up with better examples right off the top of my head, but I would point you to our website. We have a page. The Iowa Department of Human Services website has a page for mandatory reporters, and in that page there are a bunch of resources listed. And one of the resources is a guide for mandatory reporters, and it really breaks out all of our categories of abuse and gives more specific examples and things to look for, and physical and behavioral indicators and things like that. So I'm going to point you to that, because that is quite an extensive category that we do go through and provide a lot of examples. I'd encourage you to look at that, and I can actually send that website out to Elisa too if she wants to forward that along with a PowerPoint presentation.
If you didn't hear her, Roxanne said that there is a tab of resources on the DHS website that she will send me, and I can include that when I send out the post survey, and then the PowerPoint from Roxanne, and then that resource website link as well. It looks like we have time for a couple more. So the next one was asking Megan. She said, so if that central abuse registry is not a public access domain, what can a parent do to make sure when they are trying to find a child care provider that the provider's not a registered child abuse person? Is she there again? Roxanne, can you hear me? We might have lost her. If she doesn't come back on in the next couple of minutes, we can go ahead and end session, but we'll see what happens again. We apologize that, you know how this is with virtual space. Technology is always a challenge.
Well, I would say that's where it's very important to look at whether or not that, yeah, I can hear you. Am I clear?
Yeah, we can hear you now. Yep.
I'm here.
Okay, good.
I'm here. Can you hear me?
Yes, go
Can
ahead.
you hear me now?
Yep, and you started.
Okay, I'm so sorry about that. I don't know if my connection must be unstable. Okay, so the question was about childcare background checks, so whether or not they're on the registry. So I would say the best resource to look for that is work with childcare resource and referral. We contract with them to work with all licensed and registered childcare providers. You can go onto our DHS website under our childcare tab, and you can look up information about whether or not a center or an individual is licensed or registered. So centers are licensed, individuals are registered, and you can look and see if there have been complaints about them. That's all public information. And you can review all of those reports, see exactly what was complained about, how it was assessed, what outcome they came to. I mean, it's not a child abuse report. It is a licensing, it's a licensing report. So they're just basically, that's public information to share about what the status of childcare providers are. So I would encourage that. If you happen to be choosing or inquiring about childcare from somebody who is not licensed and is not registered, I would highly recommend you ask for references, and I would ask them to sign a release of confidential child abuse and dependent adult abuse information for you to get your own child abuse background check done. If they sign that form and you turn it into our abuse registry, then that information can be released to you about whether or not there is abuse on record for that individual. But again, that would have to be, they would have to sign an authorization for that.
Thank you, Roxanne.
You're
Next
welcome.
question would be, are there any policies that prevent an assessment, report, or other information being sent to a child victim or other parent if there is a no contact order or a history of domestic violence between the parents?
So generally speaking, all children and their parents have access by law to the information of a child abuse report. If there are circumstances where it's determined that that may be a safety issue, either for the child or for another parent, for that information to be released, there's a couple options. One, we could redact certain information from a report. Say, for example, if there is a domestic violence situation between a mom and dad is the perpetrator, we could, if there's information that's really sensitive in there, potentially, like, for example, about what the safety plan, the discussion of a safety plan, or I don't like to call it a safety plan because that's something we do when a child's conditionally safe, but sometimes in domestic violence situations, we work with families on having a plan for safety. So if things get out of control and you see that, you know, usually women or victims of domestic violence know what the triggers are going to be, and they can tell when things are going to escalate out of control. And those are the times we ask them to take action of safety for themselves and for their children. And so when we make those plans, of course, we don't want to share that with the person alleged responsible, because we want to make sure that those kids and that woman can be safe. And that might look like who they might call, where they might go, what they might do. And so, of course, if information like that somehow is in a report for some reason, which we generally would put in a report, but that's just an example. If there's sensitive information like that, we could redact that from the report that goes to the domestic abuser. However, if there's other circumstances where we feel like they just shouldn't get a report, period, because it's not safe, we would have to get a court order to say that there's a valid reason for that person not to receive information that they are legally required to receive. So yeah, generally in those circumstances, and that does happen at times, we would, if that's the case, we would just consult with the judge or a judge and determine whether or not we have the legal authority to withhold that information.
Sure. Yeah. Thank you. Someone asked if a county attorney, which it sounds like they had this situation, refused to draw up a China, what would happen then, or what would be the next steps, if there is any?
Well, you know, and that happens to us. I mean, as a Department of Human Services, you know, we are social workers. We present circumstances to the county attorney where we think it would be in the best interest of the child for court involvement, and we present those to the county attorney. There are times they don't agree with us, and you know, and that's for various reasons. You know, they have to evaluate whether or not we have met the legal criteria for a China assessment to be presented in juvenile court. And so when that happens, we simply document what our conversation was, what our efforts were, and so we can utilize that again if more allegations come forward or we learn about new information that might kick it to another level. Then we can consult again with the county attorney about maybe new information we have. and that's the case. If we're ever told that we don't have enough to pursue a child in need of assistance petition, we'll document the information we have, and when we get more information, we'll continue to reevaluate what information we have and what steps should be taken. But just because the court won't, or the county attorney won't pursue a child in need of assistance petition doesn't mean we can't offer services. If there is a founded child abuse case, or if the case is confirmed with high risk, we have the ability to provide DHS formal case management services. Now that of course requires the family to voluntarily work with us. And many times that's what we find. Families are willing to work with us. And they want the issues to be resolved as well. And they don't want us to be back in their lives and talking about abuse circumstances in the home. So we try to resolve those with the families when they're voluntarily working with us. And if they choose not to voluntarily work with us, and the county attorneys choose not to file that, we really don't have any options at that point except to just try to provide the best service recommendations to the family that we can, even if that means us not getting formally involved, but providing them with some resources that are available in the community, and maybe help setting them up with those before we exit.
Thank you. I don't see any other new questions for Roxanne. We have like 2 minutes. So if there's not anything else, or if there is something else you want to ask her, I can probably ascertain one more. I know there was some people that privately messaged and that wanted specific things from you. Do you want to put your email back up? Is that what you're trying to do?
Yeah, I'm getting to that.
And then I'll type it in for everybody too. Let's see, I've got one new message.
There we go.
Lots of people are just saying thank you for the information.
You're welcome. Yeah. So if you have further questions you think of later, you want to follow up with me on something I talked about, feel free to send me an email, and I'll be more than happy to share whatever information that I can with you.
I just typed in Roxanne's email address. You'll also have access to this PowerPoint, so you'll have it there as well. Roxanne, I can forward you this group chat message too, in case there was some specific follow-ups privately that maybe people want to ask you. But okay. If there's nothing else, we just want to say sorry for the audio and the some of the technology issues. That's just what happens sometimes in virtual space. We get that. It happens in physical spaces too, right? But thank you so much, Roxanne. This was very thorough. I know I learned a lot, and it looks like everybody had some really useful things to take away from this. And you're getting a lot of thank you now in the chat box. But
you're welcome.
Yeah. So we appreciate, on behalf of my organization, you spending time to provide this webinar for everybody. And everybody who participated, thank you for being here and listening. And if you need a certificate, email me. I'll put my email really quick again to everybody. And then if you're interested in any other webinars or things that we have, let me know. If you need a recording of Roxanne's email or PowerPoint presentation here, this webinar, let me know as well. And if not, I will end the meeting. Thank you again, Roxanne. We appreciate it.
Thank you, everybody.
Take care, everybody. Have a good Thursday.